welcome Ms. Deeksha, and thanks for accepting our invite. To start with, I'm also excited and happy to have Alappa University, Mr. Ayyappan from Alappa University, and the students of Alappa University was joined the program. KIT University, Bhubaneswar, then Startup Grind chapter, Jammu chapter has also joined us. I invite them all for this evening session to be conducted by an experienced and qualified professional, Ms. Deeksha. I request my co-director, Ms. Shamila Devi, to start the program.
Thank you so much, Bhaskar sir, for the warm welcome. And now we are conducting today the topic called Legal Basics, what all startups should know. This is because Deeksha actually, whenever he come across with the startups who are at the idea stage, especially, they always find it difficult to how to incorporate the organization and how to register. So many things are there. DPIIT registration is there, private sector, or whether should I register in partnership. So on this regard, we found it very, very important that some legal corporate advisors should be there for startups to address all these things. So that is the main objective of the event. And many potential startups are also there, many incubation centers in the universities where the startups are having the idea and they are looking for making it as a successful startup in the future. And on this regard, Deeksha, we need your guidance and support here for the startups and potential startups here.
Now I invite Ms. Deeksha to handle a session on legal aspects. All legal aspects for startups should know. Thank you so much for the Startup Grind for the opportunity. Thank you. Over to Deeksha.
Thank you, Mr. Ayyappan, for such a wonderful introduction. I thought we can cover during the session. The first one was different types of just legal entities that are there and how a startup is typically structured. So, there can be a partnership, a private limited company, non-profits, for-profits. So how do you choose what is the correct entity for you? The second one is startup registration, right? Because there are so many businesses that are out there. Some of them have been recently started. But what is the kind of business where you can call yourself a startup, where you can register yourself a startup under the government policy? Third point was regarding the founders agreement. What is the need and how? Because with a lot of startups, there are more than one person who have decided to run it. Maybe there are two partners or three people who have come together, bringing in different skill sets or different value add that they are bringing in. So how you can govern the relationship between the partners or between the founders? That is the third thing. And fourth point, I think, which we can cover is in relation to intellectual property and what are the different kinds of IP that we create initially as a startup and how we can protect that intellectual property. So broadly, those 4 points. And after that, we can open the floor for a Q&A. And if someone wants to ask any other question in relation to any other aspect of a startup, we can discuss that as well. Okay, so to start with, I think, and one more request. So after discussing each point, I'd be happy if someone wants to add anything or wants to put a point forward or any practical experience that you've had while running your own startup in relation to specific things that we are discussing. Please feel free to add that. I think there is an option to raise hand here, so you can raise hand and then probably you can discuss your thoughts with the group. We'll try to make it as interactive as possible so that it is more meaningful for each of the participants who are here to attend today. Now, with that, I think So the first topic that we're covering is the types of entities. What are the different types of legal entities? Why do we need to form a legal entity at all? So the general concept under the law in India and in most of the other countries is that when you're setting up a company or any other legal entity, that company is a separate person than the people who have formed that company. So if two founders have come together, set up a company, that company is a separate person in the eyes of law. So when we set up a company and if you're running a business through the company, whatever liabilities you incur, if you are say running a platform or a food tech platform or any other platform, if your customer has any complaint, if you pay your customer for any liabilities, the company will pay that liability and not you as an individual person. So it is just to create a distinction between the personal assets of a founder and what the assets of a company. And this distinction is the reason why most of the businesses set up a separate corporate entity or a legal entity to run their business so that their personal liability can be limited as much as possible. Now, there is one nature of entity where the personal assets of a founder would also overlap with the business, and that is a proprietorship. So if you register a brand name under your own name and you're personally charging for any products or services and you have a GST in your name, then you are a proprietorship, right? And all the liability that you will incur will be your personal liability. So that is the only kind of the way of doing business where your personal personal assets are exposed. But if you form a private limited company, a partnership, a non-profit company or a society, in those kind of structures, your liability is separate from your personal liability. The liability of the business is separate from your personal assets. Now, when one is deciding what kind of entity one wants to form, some people are very clear that they want to set up a private limited company only or a partnership. But a lot of times, and because these days we see a lot of social enterprises which are not out there only to generate profit, but are also doing some good to the society, or maybe they are in say a waste management space or healthcare space, or a space which is creating social impact. So those entities and those entrepreneurs want to make use of funding which comes in as donations or grants, and they also want to generate revenue or generate profits out of their activities. And that is a stage where founders are in a dilemma whether they should go for a for-profit structure or they should go for a non-profit structure. So whether you want to go for a for-profit or non-profit, that can be decided. That there are multiple factors which help you decide it, but broadly there are two factors which I think you should look at. One is that are you doing any activity where you will be charging a customer or a user? So if I want to create a platform and on that whatever I'm providing through that platform is free of cost for the users, I'm not charging users for anything. That is not a for-profit activity, right? But if I have created a platform, I might not be charging the users, but if I am showing advertisements on my platform and earning through it, that is a for-profit activity. So I have to know whether I will be generating revenue, whether I will be doing an activity which will pay me. So that is one aspect of deciding whether you want to go for a for-profit or a non-profit. The other major aspect is how do you plan to fund your activities? So if you want to, if you are going to rely heavily on donations and grants, then you will need to maintain a non-profit status, right? Because there are certain tax exemptions that you will need to have in place, and a donor would need certain tax benefits when they are making donation to you. So in that scenario, not-for-profit entity is a more desirable structure. Now, the alternative is that you either invest yourself or have, say, certain angel investors or VCs, venture capitalists or funds invest money in your company against some ownership of your company, right? So in that scenario, one would suggest that you would definitely go for a for-profit structure, but also within the for-profit structure, the investors prefer that you have a private limited company. The reason is that in a private limited company, you can take money and issue a part of your company to the investor as shares, which is which is more complicated to do in a partnership structure. So if you're seeking an outside person to come in and invest, then private limited company as a for-profit structure is more preferred. But if it is, say, a family-run business or friends and family funding and running a business, in that scenario, generally it has been observed that partnerships are more preferred. The reason is that partnership as a structure is more tax efficient and it helps you save on taxes, which a private limited does not. And if you're doing a for-profit business where you do not want to raise external funding from a venture capitalist or an angel investor, then you can explore a partnership structure. Now, within the partnership structure also, the most popular form of partnership is a limited liability partnership or an LLP structure, where the liability of each partner, if 4 people are coming together and forming a company, each person's liability is limited to a certain value, and that is something that you pre-decide when you are forming a structure, that what is the limitation of each person's liability. Before this concept of LLP or limited liability partnership was introduced, partnerships in general, they used to not limit the liability of the partners. So partners had their assets, personal assets also exposed in a partnership structure. To address that, eventually the LLP structure came into picture. So these are some very basic types of entities, private limited and LLP, non-profit. So even within the non-profit, one can explore what kind of non-profit, because there are 3 types of non-profit which mostly exist in India. One is a society, and second one is a trust, where you set up a trust, and the third is a company. So like there is a private limited company, there can be a non-profit company as well. So these are the 3 non-profit structures, and there are different, reasons for incorporating different kinds of structures. So depending on what is the nature of your business, what are the activities that you plan to undertake, how do you plan to fund your activities, you can decide whether you want to go for a for-profit or a non-profit structure. And within that, what kind of entity specifically you want to go forward to, whether in the for-profit, you want to set up a private limited company, a partnership, or in a non-profit, you want to set up a non-profit company, society, or a trust. Apart from these very basic structures, certain very specific kind of businesses also have very specific structures. For example, if I am promoting local produce, or I'm into a business which is producing agricultural products, I can go ahead and form a producer company, which is a very different company from a normal private limited company. If I want to set up a structure where people are coming together and funding each other's activity, maybe in small amounts, I can form a cooperative society, and where people can save money, fund a little bit, support each other. Then at very basic rural level, we have heard about it, that women of a village have come together and formed a self-help group, right, where they are taking loans from the bank and maybe making some crafts and selling it. So those are very different kind of structures which are specific to the nature of business. So having said that, are there any questions or anyone has any thoughts that they would want to share on the different types of entities that we have in India?
Deeksha, actually, there is a question from a few of the startups, potential startups. They have questions like in which time they have to make the LLP into the private company. Is there any norms for that? In which time they have to change it, or is there really need for the need to convert the company?
Yes. So if you want to convert an LLP into a private limited company, first we have to figure out, is there a reason for you to do it? If there is a reason for you to do it, then there is a process given under law through which you can convert your LLP into a private limited company. Okay, it is possible, and it is possible at any stage of the business. Okay. But this entire process is the amount of time and documentation that goes into the process is almost equal to setting up a new company by itself, right? So sometimes what businesses choose to do, especially if they are at a very early stage, is that rather than converting an existing LLP into a private limited company, they would form a new entity, which is a private limited company, and transfer their business from the LLP to the private limited. This has two benefits. One is that the new company is a fresh company.
Okay. Okay, I think Deeksha has some network problems. Let her come back. And yes, welcome Abhinish from SG chapter, KIT chapter. So is there any questions from the participants? Please post the questions on the chat box. And she's now ready to answer all the questions record from the participants. Please do share your questions. Let me check. Bhaskar sir, if you want to share anything, please share, sir. I will.
Okay.
Come back, Deeksha. We are waiting for you.
She has come back.
Okay. Sorry, might be some network issue.
Yeah.
So I was just saying that one can transfer their business from the LLP to the company, and so when one is transferring the business, we can pick and choose what we want to transfer, and if there are any liabilities that are left in the LLP which you want to settle by closing the LLP, that you can settle in the previous entity, right? So it is like a start. It is a fresh start. The other benefit of forming a separate entity is that, and why people prefer is mostly the reason that people set up a private limited company if they have an LLP is because they are looking at external funding. So they either an angel investor or a fund or a VC is wanting to invest in their company, and they want, and the VC doesn't want liabilities of an LLP to come to the private limited company. So these are the two reasons because of which a separate entity, people have chosen to set up a separate entity. But legally, there is a process where you can convert the LLP into a private limited company at any stage of your business.
Now it's clear, Deeksha. And another question is, the government of India is insisting every startups to have DPI registration. So why is it important for startups to have such registration for themselves?
So DPIIT registration is to categorize a company as a startup. Now, the entire concept of recognizing a startup is to promote innovation and to promote job creation in the economy. So not every startup or not every new company is doing that, right? So it is to segregate the companies which are either innovating or are creating multiple jobs, from any other company, which might be just a new company, which might not be innovation driven and is not creating a lot of jobs in the economy. So for that, the government certifies new companies as a startup. It also has certain qualifiers. So to qualify as a DPIIT registered startup, so DPIIT is Department for Promotion of Internal Trade and Policy, right? So in this, the DPIIT registration, they would look at a startup and assess if that startup is an LLP or a private limited company or a non-profit. If that startup is innovation driven, if they're creating innovative products or services, or if they are providing any existing product or service in an innovative manner. Okay, so I might not be giving a new service, but the same service in a manner which is more innovative. And the third is if I am creating a lot of jobs. So if I'm satisfying either of the three conditions, then I can register myself as a startup. The benefit of registering is that once I've registered and government recognizes me as a startup, then I can go ahead and apply for multiple other benefits. So one is a tax benefit. As a startup, registered startup, I can get up to 3 years exemption on income tax. Then as a startup, I have relaxation on the fee that I have to pay to the government if I want to register a patent, trademark, or make such applications. So for all these applications, there is a relaxation that is given. Otherwise, these processes are costlier for any other company which is not a startup. The third benefit is if I am raising funding from an angel investor, there are certain tax benefits that my investor will get, right? So investors are also incentivized to invest in a startup which is registered with DPIIT. There are multiple government schemes at national level also and at state level also, which are targeted to DPIIT registered startups only. So which includes when we hear of government funding or just a few months back, Prime Minister announced that about 900 crore worth rupees of fund for startups. So when the government is announcing such a fund, they are announcing it for registered startups only. And then they incentivize the investors, the incubators, the accelerators to take that money from the government and invest in recognized startups. So that is the purpose of the registration and multiple benefits. So if one visits the website of Startup India, the website itself it's a very resourceful website. It has the entire scheme policies, and at local level, you can see the policy of, say, the government of Kerala or of Tamil Nadu or Maharashtra. Different states have different policies, which also you can access on that portal.
Great, Deeksha. Actually, you have given a very good clarity, and it's very clear for the startups here. And yes, actually, that was the main confusion. And nowadays, the government is very good in giving seed funding for the startups, and many schemes of seed funding is also there. And there is one question from the participant, Umar Farouk. He's asking if any foreign company want to register in India, what are the common normalities and requirements?
Sure. So foreign company which wants to do business in India, there are different ways in which a foreign company can do that. So one is that they can do some sort of activities in India without actually registering a company. So for example, foreign universities, if they want to target Indian students, they don't really need to set up a company in India. They would set up something called a liaison office or a branch office. And RBI has specific guidelines on what these offices can do. So these offices can maybe just undertake some marketing activities for them, and they can still operate in India. But if a company has decided, a foreign company, that it wants to set up a company in India, then they would set up a company subject to certain limitations. One is that if that company is a subsidiary of the foreign company, which means that the foreign company is controlling the Indian company, then there are limitations on FDI. So foreign direct investment policy of India has limitations on certain sectors. For example, we keep hearing that FDI of X% is allowed in military, or Y% is allowed in media and broadcasting. So those are the percentages limitations, and to that extent, a foreign company can hold or control an Indian company. So that company which we set up in India for a foreign company has to be in compliance with FDI regulations. And then apart from that, the normal procedure for setting up a company in India is followed. Foreign companies also prefer to appoint a foreign director on the board of the Indian company, which has certain additional requirements, certain additional KYC requirements, right? Because it is a foreign national. And those are just the filings which one needs to make with the Ministry of Corporate Affairs. And you can set it up as a private limited company, as an LLP, or whatever kind of structure that you want to set.
Great, Deeksha. When Farooq was asking this question, I have another question. Like nowadays, Indian startups are looking for some foreign investors to invest in their startup.
Yes.
So if it is the case, if they have already registered as an Indian startup, if they are getting some investment from others, other investors from other countries, so what is the formalities there?
So one formality which is common for all the companies which are raising foreign funding is that they have to comply with FEMA regulations, which is Foreign Exchange Management Regulations, which requires compliance with the FDI caps, sectoral caps, which are there, which we talked about. In certain sectors, only certain percentage is allowed. Apart from that, you have to disclose such investments to Reserve Bank of India. So there are specific filings called FCTRS and FCGPR, etc. Depending on how they are investing, right? So if you're issuing shares directly to the foreign investor, or if they are purchasing shares from an existing shareholder, then there is a compliance. That is a typical, investment. Nowadays, there is a new instrument which government has allowed, which is a convertible note. So a convertible note is not giving shares. It's you are taking loan from a foreign investor in that concept, and you don't. So we hear about valuation of companies, that the company is being valued at X amount, but a company which is a startup at a very initial stage, it is difficult to value. So investors want to invest, but without valuing the company. So convertible note is an instrument which allows them to do that. So they give a loan to the company, and you have to disclose it to the RBI also that this loan you have taken. And at a later point in time, when you raise the next round of funding and your company is valued, at that point in time, that loan will convert into shares of the company, right? So this is a new process which is nowadays being followed and is very popular amongst the foreign investors.
Oh, great. Actually, it's a new thing they have updated, and thanks for sharing this with us, Deeksha. And one of the question from participant Soundarya: can one DPIIT registered for startup at very early stage only at idea level? So
yes,
early stage
you
level or idea level? Okay.
You can be at an idea level. You that is not a problem, but you just have to disclose it in the application.
Okay. Then another question from Ayappan sir: how to register service-oriented organization like consultancy and training-related organization?
So it depends. So if it is a consultancy, it is mostly structured as a for-profit private limited company. So it's a normal private limited company which can be registered. It can also be structured as a partnership, a normal consultancy firm. But if it is a training institute, it depends because a lot of training institutes are set up as a trust or a society because they make use of donations. So there has to be some structuring there, and usually they are parallel structures where there would be a certain for-profit entity also and a non-profit entity also. But the challenge with two entities existing in parallel is uh, that, just to keep those two entities very separate from each other at all times, including how the funds are flowing between the two entities, that has to be accounted for in a proper manner to ensure that there are no questions from tax authorities on why a certain fund was transferred, etc. But mostly training institutes are set up as trusts or for societies, and they have a parallel for-profit entity.
Okay. I think, Ayyappan sir, you have got the answer. Before getting patent on the idea while hiring team members, how to create non-disclosure agreement so that I can protect my idea. So from Soundarya again.
Yes, I think this is a good question because at the very initial stage, it's not only for patent but even for copyright. So certain kinds of intellectual property, the right to that IP is that of the creator, right? So if I'm creating an app, if I am the creator of the app, I automatically have authorship right of that app, right? If I'm writing a book, I am the author of that book. But if I am doing it for someone else, then it has to be recorded in my contract with that person that it is a work for hire. So the concept of work for hire is I'm working for someone else. So when that thing is created, the right of that or the patent or the copyright will be of that company or that other person for whom I'm working. So when there is a proposal that a service provider sends to you for creating something, just ensure that in that document which you're signing, because at very initial stages, people don't really sign agreements. It is usually a proposal and a fee is decided. But please ensure that in that proposal you mention it specifically that this is a work for hire arrangement where you're working for another person, and whatever you will create is going to be owned by the other person.
Okay, I think Soundarya
Yeah,
got
I
this.
just
Yes.
one more point to add. I think non-disclosure agreement is why that is very pertinent is because the enforceability of non-disclosure is very tricky. We can't. So if someone is a techie, that person will always provide technical services. You can't in the contract write that you will not create app for someone else. You can't write in someone's contract, right? It is also unconstitutional. You can't restrict a person from practicing his profession. So the way to restrict is that you have to put certain limitations. If I am creating Zomato app, I will write in that person's contract that you will not create an app which is an aggregator of restaurants. I have to be very specific, and I have to put a limitation that in the territory of India, you will not create that app. If you create one in US, I don't have any problem, right? So those are the kind of restrictions. If you build that in a non-disclosure agreement, then it is tomorrow if you challenge it, it is enforceable in the court of law. Otherwise, it becomes an issue to actually practically enforce such agreements.
Very nicely explained, I think. I think she has got the answer. Soundarya has got the answer. And when entering into the startup journey, when nowadays we are having a team like co-founders and sometimes consultants, mentors. So what is the need for having an agreement with the founder or mentor in the team? Or how can we make it? Whom should be approached?
Sure. So a lot of incubators and accelerators and also mentors, because now the industry is booming a lot, have an arrangement with startup where they are mentoring the startup and they take certain equity or a service fee from the startup at the very initial stages. The complication with this arrangement is that the startups sign these agreements, and have personally come across instances where after giving away, say, 5%, 10% equity to an incubator or an accelerator, the startup feels that they have not added any value, right? And so I think when you're signing such an agreement, and specifically if you're giving away equity, it's ownership of your company. I think entrepreneurs need to be very stingy about it. And so don't just distribute it. I mean, it should be based on outcomes. So not that someone will provide you mentorship. That is very vague, that is very wide. So specifically that why are you looking for mentorship is something that an entrepreneur has to be clear about. So are you looking for it to increase revenues, add clients, or to raise funding? And put that specific thing in your contract where you're giving away equity, right? That if I get 10 clients or if I generate this much revenue, then I will give equity. So that will make more sense for you. And as an entrepreneur, you will also not feel like the other person has not added value. Because if you put something very vague, the other person will feel we have worked so much for the startup. And as an entrepreneur, you will feel that there is no value add. So it's just helpful to be as specific as possible when you're going for such arrangements with for services, mentorship services, incubation, whatever kind of service it is.
Thank you so much, Deeksha. And I think Madhavan has one question. Can you tell about the cliff and vesting agreements period while bringing in partners?
Sure. So this is a very important part of a founder's agreement. So just let me explain what cliff and vesting is. Cliff period is that if there are two people who have come together to set up a company, so there is a certain level of commitment that both the people expect from each other in terms of time, right? So the entire concept is that on day one, because you might set up a company and you might be technically owning shares, but on day one, there is this hypothetical concept that you cannot. So what is the value of shares for an entrepreneur? On day one, your shares don't really have any value unless you build the company, right? And your shares will give value to you when you sell them. On day one, or maybe for next 5 years, 10 years, the shares are worth nothing. So the what happens in those first few years is that you bind the person, your partner or partners bind each other with a cliff provision and say that for next 1 year, you will not transfer your shares to any person at all, right? Or, then after 1 year or 2 years or whatever the cliff period you decide, after that, you can transfer 5% of your shares. After 2 years, you can transfer 20% of your shares. After 3 years, you can transfer 40% of your shares. So this is a gradual process in which the founders themselves are earning their shares. So this is the concept of cliff and vesting provision. So it's important for founders agreement, but even when investors are investing in the company, they would reset this, they would want to reset the provisions, because for them, the company is nothing without its founders. So any investor would want to retain the founder to run the company. Investor is not going to run your company. They will just put in the money. So they would put in similar provisions where they would retain the founders in the company by putting in cliff and vesting provisions. This is also something which you can put in these concepts when you are issuing ESOPs to your employees or options to your employees to incentivize them and give them shares at a later point in time.
Right, there are a lot of things in it. I think even myself, I know about this now only. I think Madhavan, you have got the answer. And Bhaskar sir, is there any question from you for Deeksha?
Yeah, as you said, when it comes to the founders agreement, there is that cliff and vesting model. That's the only thing in the founders agreement. Normally, it gets confused when as progress is going on, isn't it? So,
yes.
So is there a way to fix the valuation for the transfer for at every stage, or it has to be valued separately for each transfer?
So the vesting provisions are hypothetical in nature, because on day one, anyways, the founders are owners of the shares, right? If there are two people owning 50%, they own the shares. So though the question is in terms of vesting, but concept is called reverse vesting, because I already own the shares, but what I don't have is the right to transfer them. So if I can't transfer them to someone else, I can't derive value out of those shares, though I might be owning them, you know. So you don't really transfer the shares when vesting happens, but it's just that you gain the right to transfer those shares. Now, I think the complication which you mentioned arises if a founder is leaving, say, after 2 years, when only 50% of shares have vested and 50% have not, right? So what do you do with those 50% which have not vested? So you will have to purchase it back from the founder. And that is the time where, price comes into question, because the value of the share at that point in time might be, say, 500 rupees a share. But if I don't want to give a founder who is leaving the company that value, because the founder has not earned those shares, right? And so at that point in time, usually contractually it is agreed that, at face value, or whatever is the minimal value of shares, maybe 10 rupees or 1 rupee a share, is the price that I will pay the founder to get the shares. But there has to be some price that has to be paid. You can't, transfer shares at a price which is lower than fair market value, unless obviously you can do gifting, but you have to justify. Gifting is very rare because it has to be within family members and relatives, and you have to prove all of that. So usually that transfer is done at a face value of shares, which is either 10 rupee or 1 rupee a share. So the founder is not gaining anything out of that transfer, and is also not getting the shares which have not been vested. Though it has some challenges from tax perspective, but this is the process which is generally followed.
Oh, okay. So when you're signing the shareholder agreement at the time of investment, so for the founders' shares has to be valued at the same price, isn't it?
Yes, all shares have to be valued at the same price at that point.
Okay, thank you.
Okay. And Deeksha, when they are going for investment, some investors are asking the equity like 20%, 30%, 40%. When there are when the startup is having more than one founder, so how can they divide the equity? And so already they are having 100% share. So the investor is asking 20% equity. Sometimes nowadays even the mentors are also asking equity. Incubators are also asking equity. So how can the founders manage out of this?
So when someone is asking for equity, it does not mean that founders have to give their shares to the person. What happens is that company will issue fresh shares, new shares to a new shareholder who's coming in. So yes, founders will get diluted, because now, so for instance, on day one, when you set up the company, there were 10,000 shares, 5,000 each founder was holding. So both had 50% of the company. An investor comes in and you issue, say, 200 shares to the investor. So now, which is a fresh issue, so you're not selling your shares to the investor. The company is issuing new shares to the investor. So the total number of shares or of the company is now, 10,200. And out of that 10,200, you own 10,000, which is X%, and 200 is whatever, Y%, and X plus Y is 100% of the company. So what happens when a new investor comes in? Right now the company is divided, the ownership of the company is divided into 10,000 parts. When a new investor comes in, you divide that ownership from 10,000 to 10,200 parts, right? And you remain with 10,000, and 200 you give to the new investor.
Oh, that's great. It's getting clear, Deeksha. And again, Madhavan has another question. Can the founder still get profits, if any profit is there, can still get profits from those shares during the vesting period?
So there are different ways. So some companies offer dividends, they announce dividends, but at the very initial stage, startups prefer not announcing dividends. The reason is that it is not a stage which is seen as something where you can derive profit out of the company. It is the stage where you're using the revenue to pump it again into the company so that the company can grow. So at the very initial stages, the way founders earn is through salary. So you fix a salary with the company and you draw that fixed amount from the company over a period of time. When you get funding, at that point in time, a lot of founders negotiate with the investors to increase their salary, right? And that is how the founders earn while running a company. And ultimately, if they sell a company or at any point in time, then they earn out of the shares. So founders are engaged with their company as a shareholder separately and also as an employee. So maybe one of the founders is a CEO of the company, because founders are doing the job for the company at the end of the day, right? So that is the concept. So you also have an employment agreement with the company where you are a CEO's employment agreement is what you are signing, and you have requisite liabilities under it, and you have requisite salary under it. You can claim reimbursements from the company. That is how you run it.
Thank you, Deeksha. Actually, you have a lot of information you have shared, and it is very clear and it's demonstrated one by one very clearly out of the questions asked. I think it's almost time, and I think it's a very vast topic to consider. For startups, it's not a 30 minutes, 40 minutes job to deliver whatever it is needed. Anyway, we have time constraints and we value your time too. And that's good that you are here and you have cleared doubts for many of the people who have asked and other potential startups here. Thank you. Now I would like to invite our chapter director, Mr. Bhaskar Perumal here to give the thank you address.
Thank you very much, Ms. Deeksha, for sparing your valuable time and answering the questions in a very calm and even more than that, in a very not using any technical or words or something, in a very simple and understandable words to the audience. Thank you very much for this wonderful session. And thank you. And thank Mr. Ayappan Arumugam of Allahabad Institute of Management for joining us in this event, and also for the students of Allahabad Institute of Management joining the program. In fact, they have been very active, and I think if left to them, the session would have continued for another more time, I think so. Thank you very much for joining us. And special thanks to the KIT Bhubaneswar chapter director and the members of that chapter for collaborating with us in hosting this program and also participating in the same large numbers.
Thank you, Bhaskar sir. The pleasure is ours. It was really a wonderful event. Even we got to learn a lot about the law side of a startup. We as techies, we as engineers knew only about the product, and today I understood a lot of new things. So I'm sure that we'll be discussing this in the next meeting of ours that we'll be having in our college chapter. And plus, like, it was wonderful. I'm sure a lot of kids will be having fun talking to each other about this new information that we have come across. Thank you very much.
Thank you. And my thanks to Ms. Rishita, Director of Startup Grind Jammu chapter, for collaborating with us and also joining in large numbers of the members of the Jammu chapter for joining us. Thank you, Ms. Rishita.
The pleasure is ours. It was a wonderful event, and I hope that everyone must have learned at least one thing from here. There was so much to learn, and yeah.
Okay, thank you very much. And for finally, as I said, my special thanks to my co-director, Ms. Sharmila, for organizing this event and in fact connecting with a wonderful speaker like Mr. Deeksha. And she has always been a pillar for this Madurai Direct chapter. She's the one who is keeping it vibrant for the last 1 year. Especially thanks to Sarmila. And once again, thanks to everybody for joining us, and thanks to the chief guest for sparing your time. Thank you. Thank you, friends.
Thanks a lot, Bhaskar sir. Thank you everyone for joining. And Deeksha, do you want to add any final note?
Thank you so much for inviting me. When constantly working on the legal side with startups, sometimes we lose focus on what problems are there, on ground in the field. So it's always very insightful to talk to entrepreneurs and listen to them and answer their queries. It gives me also an insight into what is the exact challenge that people are facing or startups are facing currently. So thank you for inviting me.
It's a great pleasure, and thank you so much, Deeksha. Thank you everyone here. Thank you all the partners.